Welcome back, everyone. I am Mark Reel Jr., the host here, back with Arkansas Attorney Brian Vandiver. So we have spoken about the best practices, how you guys were able to get in front of legislators, how you were able to educate them. Let's take a step back and go broader. So walk our viewers through, what is the legislative process from a bill being introduced to a bill becoming law in the state of Arkansas?
So in Arkansas, our session, we have a legislative session that meets every 2 years for big policy changes. We have a fiscal session that meets on the off year, but it's every odd year that our main session meets. And so after we failed in 2019, we kind of had a 2-year plan to say, okay, 2021, we're going to come back. The first step is getting your bill written in advance of far in advance of when the session actually starts. Because if you're writing your bill and getting it filed after the session starts, you're behind the game. You need to have your bill written and ready to go, I would say at least a month, if not 2 to 3 months before the session starts, so you can get it filed as quickly as possible on day one. We were lucky enough to be the 18th bill filed in the Senate, so we were early in the filings of the Senate bills. That does a couple of things. One, that puts you in the first of the lineup for bills to be considered, but also that also lets you start educating legislators and other interested parties on what your bill is about and what it's going to do. So you have to have a plan many months in advance of when the session actually starts. Once the bill is filed, whether it's in the Senate or the House in Arkansas, it has to go through a committee. Fortunately, ours was filed in the Senate as a Senate bill. It's where it originated. And Alan Clark, who was our sponsor, is the chair of the Judiciary Committee, fortunately. And so it was assigned to the Judiciary Committee, where he championed it through. And that was, of course, fortuitous for us because we knew that we would have a strong advocate in the Judiciary Committee. It failed in the Judiciary Committee in the House in 2019, so we were hoping to have it assigned to a different committee in the House, and we did. We were able to get it. Somehow it was assigned to another committee. And I'll just say that the Judiciary Committee in the House side in Arkansas has lawyers involved, and it's much more problematic than we wanted it to be. So we were able to get into the Youth Aging Committee, and we had a strong presentation in that committee. We had a lot of dads come in and testify, a lot of professionals come in and testify, veterans. I testified. We had a surprising testimony from a therapist that I know and respect, Elizabeth Ruggiero, who's a marriage counselor and children's therapist, and she just knocked it out of the park as to why joint custody should be the norm. And so we had a lot of advocates come and testify, and you have to have that support. You have to have people show up to committee to testify. And because the opposition is going to be there, and we knew who our opposition was from the outset. It was the family lawyers primarily and the judges that were opposed to it. We did have some family lawyers who had the courage to step up and testify in favor of this bill, Kevin Hickey and Greg Crumpton and some others who they stood up and they did the right thing. And you have to have lawyers involved who will say, this is the right thing. This is what we need to do from a policy standpoint, not what's best for lawyers or family lawyers. And we had that. And you have to have that to combat those who are going to oppose it. And then you have to have people to say, despite what these judges are telling you, this is what's best for the state. And we had that as well. So we had a great presentation in committee. We were able to get it through committee. There was some pushback that we had to make an amendment. And so whenever you have an amendment process, it has to go back through committee. The main part of the amendment was that we were afraid that our bill wouldn't pass if the presumption applied to both new cases and existing cases. And so the concession we made was that the presumption part of the new law only applies to new cases that have never had a custody order. But the other parts of the bill will still apply to modification cases. So we had that amendment. We had to go back and get it through committee. We did that. Again, it passed the Senate 33-2, passed the House 71, I think, to 16, if I remember correctly, and signed easily by the governor. So that's the process. And then in Arkansas, once a bill is signed, it takes effect 90 days after the end of the session, which our end of the session was at the end of April. And so Monday will be the day that most laws take effect, unless there was a bill could have an emergency clause on it, but ours didn't have that. So.
Gotcha. Okay. So we got introduction of the bill. You're going to go through either the House or the Senate's committee. And then you're going to go to the floor for a vote in that chamber.
That's
then
right.
You go to the other side, you got to get through committee and go to the House. There can be amendments and it has to go back and forth, get passed around. Ultimately, you need both chambers to vote in favor of it. It goes to the governor's desk in the state of Arkansas. 90 days after the session's over, it becomes law.
That's right.
That process is a process that plays out pretty similarly in most states. That's going to be the process that a bill is going to have to go through. You mentioned something that I think is always a topic of conversation in knowing your enemies. And you cited really two of the three groups that are usually the ones who hardest against a presumption of a 50-50 presumption in family court. The bar associations, the family law attorneys, the judges associations, the individuals who currently have all the power and discretion. And then a third group you routinely see would be domestic violence groups or women's groups that will hop in. We've seen it in states like West Virginia, where National Organization of Women came in and made a huge push to keep that presumption from coming into play. So for the two that you mentioned there, the family law attorneys and the judges, how did you guys go about combating those groups that, let's be honest, are more well-funded than the equal and shared parenting groups that are trying to drive this bill through?
Well, what we did was our sponsors of the bill, Senator Clark, primarily had an open dialogue with any opponents of the bill, and he said, "Look, this is our goal, this is our bill, and we're going to pass something, and we welcome you to help us improve the law, and we are open to any suggestions you have to how we can improve the law." And he opened that conversation, had meetings with him, several in-person meetings, Skype meetings with judges, with family law attorneys. But at the end of the day, they just could not support a rebuttable presumption, any rebuttable presumption, because they wanted the discretion to remain with the judges. And that's just not what our goal was, and we weren't aligned. So we did take some of the language that they proposed and incorporated it in the final bill. But at the end of the day, our goal was to have a rebuttable presumption that could only be deviated from with clear and convincing evidence. And that standard was so critical. There was one point where we were having our discussions, and the idea came across, the judges really want us to cave on this clear and convincing evidence to get it done. Do we need to do that? And I said, absolutely not. And others said that as well, because if we cave, then nothing really is going to change. If it's a preponderance of the evidence, for the viewers that don't understand the burden of proof, a preponderance of the evidence means 50% plus anything else. And the way I describe it is, if you have the evidence falling and a feather of evidence falls one way or another, that's preponderance, and that decides the case. And so to have that feather of evidence fall one way or the other to make the distinction between custodial parent and non-custodial parent every other weekend is a huge impact. And that's why the burden is so important, because in Arkansas, we already had in our law, in other areas of the law, the definition for clear and convincing evidence. And that means evidence that produces a firm conviction in you that the allegation is true. Or in another way, proof so clear, direct, weighty, and convincing as to enable you to come to a clear conviction of the matter asserted. And that's the standard that we should be using in custody cases. If we're going to terminate parental rights, I mean, that's the standard that's required for the state to terminate parental rights, right? That's the standard they have to meet according to the U.S. Supreme Court. So if it's parent versus parent, why shouldn't we also require that standard to terminate parental rights? And we should. This is not a car wreck case. This is not a case that a contract case. This is a case that impacts people's lives forever. And I don't do family law, but I've experienced it, and I understand it.
Yeah, I mean, I've had attorneys who now practice family law that were public defenders that handle PI cases, and every single one of them will say the most stressful thing is thinking about someone on preponderance of the evidence losing either all or a significant portion of their parental rights. So I definitely applaud you for standing firm and standing your ground on that clear and convincing evidence, and explaining that to the viewers, and only an attorney could write that, or a judge somewhere, I'm sure, in the state of Arkansas, decided they wanted to be the one to define what that meant.
Well, we hope that other states will follow suit and really adopt this burden as well, because it is a game changer. And I think we will see in Arkansas, I don't know that the number of custody cases will change all that much, but I think that there will be a huge change in the amount of litigation and time that is needlessly spent on whether someone is a fit parent or not, on frivolous issues that you shouldn't be fighting about. And I hope that's the case, and I really think it will be.
I, as a practicing family law attorney, my first thought of this is there's almost never settlements prior to the first hearing. If you have a 50-50 presumption, and I was trained as a labor and employment attorney, you're a practicing labor and employment attorney, the law is a lot more clear cut, and you end up usually settling. Very few cases actually drag on in that area of law, because both parties essentially know the small window that the case will eventually fall into. So my first thought on these 50-50 is that as an attorney, unless there's a legitimate substance abuse issue, which is serious, unless there's a legitimate domestic violence issue, which is obviously serious, unless there's some issue along those lines, both attorneys are going to go in knowing that, okay, either the parents and us can come to an agreement and tell the judge what we want, or the judge is just going to slap the 50-50 on there. So as an attorney, I think in my mind, I think it's going to make it easier to settle early on, because the burden is going to be much higher to create something different or to drag things out.
And that was our goal. That is our intended goal. That's our hope, to reduce litigation, to encourage settlement earlier through this rebuttable presumption, because as I know and as others have experienced, the more litigation there is, the deeper the scars are and the harder it is for the parents to heal and move past litigation. And if you can take some of that litigation away and settle it earlier rather than later, I think it only benefits the children in the long run.
Yeah, definitely. And I mean, we've already seen it. I think something that's going to be very compelling, obviously now we're going to get the state of Arkansas here in a couple of years. Statistics are going to start to come out. We've started to see those statistics, and I'm sure you use them in your state, that have started to trickle out from the state of Kentucky, where the number of hearings is down, the number of domestic violence cases is down. That a lot of times we didn't really talk about in terms of the enemies to equal and shared parenting, but those domestic violence groups that come and say this is protecting the abusers. And we're starting to see, if we get more and more states on board with this, I have a gut feeling that the statistics are just going to become overwhelming, that it's going to become that tidal wave that 2-3 years from now, if you're a legislator that does not support this 50-50%, you're going to have that kind of scarlet letter moving forward of you supported discrimination.
That's right. That's right. And that's what it is. This is a civil rights issue, an equality issue, and they are going to be on the wrong side of the issue if they don't support this type of legislation. And so the statistics will keep showing that. We're confident the statistics from Arkansas will show that, and we will keep fighting the good fight.